Let's bring in our guest for this hour, who is standing by remotely to discuss. Joining us from Detroit, Michigan, national trial attorney Michael Jaafar is with us. Michael, tell me what you think about this case. It's similar to the Thompson trial that we are following also in Florida, but there are some differences, perhaps in how people may view Ashley Benefield versus how they've been viewing Marsha Thompson in a similar self-defense, battered spouse syndrome type case. Your thoughts?
It's so iconic that both of these cases are taking public attention at the same time. The difference between these two cases, obviously, is that in the Black Swan murder trial, she's only hit with a murder 2 charge, whereas Marsha Thompson is with the murder 1, the premeditated murder. The evidence obviously is different, but both of the analysis is going to be the same: battered wife syndrome, right? Obviously, also with the Black Swan with Benefield, we have the prior testimony in the custody hearings when they were fighting over their kids, and it's not known whether or not her husband yet, from what we've seen, was in a defensive posture. He was standing up. Some experts say that he was shot from the side. He was not facing her, but there's also a shot in his chest. Whereas with Marsha Thompson, it's pretty clear by now that she shot her husband while he was laying down. That doesn't mean that she's going to get convicted. It's completely different. However, both of these cases have the same. Law school professors right now are teaching both of these cases across the country in their criminal procedure classes to all of their students on the week when they educate them on battered wife syndrome as a defense, because battered wife syndrome is a complex defense. It's not as easy as self-defense. Hey, I'm a stranger, he was a stranger, he reached for his gun, I grabbed mine first, I shot him. It's complicated, right? You can in fact get off for murder by saying that I was abused, I thought he was going to kill me, and even though he wasn't going to kill me, I thought he was. So I think both of these cases are prolific right now for every legal mind, and I'm really curious to see what happens with both, because both of them have a different flavor on this defense.
I think it's so helpful that you mentioned how complex and complicated battered spouse syndrome cases are. We've seen situations where it's a wife who had to kill a husband in self-defense, and the battered wife syndrome was not raised as a defense. And it's been curious, but a lot of attorneys who have analyzed it have said it's a difficult thing to bring forward. You have to get an expert to be on board with it. There's a lot of analysis of your client that you have to open them up to be able to be interviewed by the expert from the other side. So going forward with that, as you mentioned, it is complicated. Do you think it adds to the challenge for the defense in the Ashley Benefield case that there is no testimony yet that we have seen that Doug Benefield ever attacked her physically? You heard the mention of the gun being fired in her presence, that he threatened to take his own life in front of her. She accused him of poisoning her while she was pregnant. But in terms of what we heard in the Thompson trial so far, of the punching and the beating and the dragging by the hair and that sort of physical combat, we don't have that. How much of a challenge do you think that could be in the Benefield case?
It all comes down to the opening statements. I remember in the opening statements for the Marsha Thompson case, the defense attorney stood up there and said, while he was abusing her, while he was throwing remote controls at her and laying on the couch, she would walk up to him and massage his feet, because in her experience, massaging his feet would calm him down, right? So if you're a juror, you're seeing the visceral scene laid out for you by the attorney, which is you're being abused and disrespected, which is even worse, yet your response is to massage someone's feet. So in the Benefield case, in the Black Swan murder trial, it comes down to the opening statements and whether or not the attorney can paint it in that kind of a visceral light. If what it comes down to is he was just rude to her, he threatened her, they had a contentious marriage, she pulled out a gun and shot him when he wasn't looking, if the state can prove that, then I don't think a jury is gonna go for it. Also, you're looking at a very young, very beautiful woman, very vibrant woman who's very well known, who's a famous ballerina. Juries they're gonna know, like, why did you feel that you were stuck to this person and your only way out was to shoot him. I hate to bring that up, but that's what a jury, because I'm looking at what a jury would do. A jury, if I was talking to her, I'd tell her, listen, these jurors, they're going to be looking for ways to say that you're a murderer. Don't think for a second that they won't feel that way, because these jurors, none of them are going to be ballerinas. So we have to prove to them that you were helpless, kind of like we feel today with Marsha Thompson. We feel like she was helpless. She was in a marriage with a monster, and her only way out was murder. We have to be left with that same feeling with the Black Swan murder trial with Benefield. Her and her defense attorneys have a very difficult challenge, and they have to prove that to the jury.
Yeah, Marsha Thompson's attorneys have had to overcome her being a law enforcement officer. That was a difficult thing, I think, to overcome. We'll see what the jury believes, but to say that this law enforcement officer who has all of these resources, has a weapon at all times, has all of this training, didn't feel like there were any other options rather than to shoot her husband while he was on the couch lying down. So you bring up a good point about the former ballerina aspect for Ashley Benefield, that it may not automatically mean that they're going to look at her as someone who is helpless, but they may say, look, you seem that you should have had options. It's interesting analysis, and every juror is different. I want to go back to a piece of evidence that actually was disputed. The state didn't want this 911 call to come in because they said it was essentially a self-serving statement, that it was something where the neighbor is repeating what Ashley Benefield told him when she rushed over to his house and explained what had happened, what she had done. But let's listen back to that 911 call and talk about the judge's decision on it.
So they were in an argument?
I don't know. She came in. She was quite hysterical. I didn't know who was banging on my door. Said that he attacked her, and she shot him. They've been having trouble.
Okay. I'm just getting that all on the screen, okay?
Okay. Calm down. I know.
Okay,
it's not what people think it. It's not what people think it is. I know.
Yeah.
Go ahead, ma'am.
Where is the gun? Is it with her, or is it just...
I have it right here, ma'am. It's sitting on the floor inside the door. My door's locked, so in case he isn't, he can't get up. I'm also armed if he does come over and try to harm her, just so everybody knows.
Okay.
I'm kind of concerned with her mother, and the little girl might get back there and find this, whatever happened.
The deputies are running as fast as they can, okay?
Okay, I hope so. I've been worried about them for so long.
Okay. Have they been having issues recently?
Beg your pardon?
They've been having issues recently?
I'm not too sure how long. I'm not sure.
So the neighbor there relaying this fear and showing that he's going to protect her because she's in this vulnerable situation. That can be powerful. Michael Jaafar and the judge did, over the objection of the state, say that it is coming in. So the state said, well, we're going to bring it in our case in chief. Who do you think should bring it out first in their opening statement, if that's allowed?
I think we've seen many. I've always given the analogy, when I'd get a bad report card as a kid, I'd call my dad when he was at his office and tell him about it because he had 5-6 hours to stew on it. So I've always given that analogy. The state has to bring it out. They had to file their motion objecting for the evidence to be introduced, but this is clearly should have been introduced. This is absolutely a known hearsay to the exception rule. 100% that was going to be admitted. I mean, for many, this passes at least no less than 3 exceptions to the hearsay exception. So I think the state has to bring it out because primacy and recency, right? You don't want to end the trial. You don't want the last, because this will be the last thing that the defense, if the prosecution doesn't bring it in, this will be the last thing that the defense will bring in, kind of as like a, kind of like a mic drop moment, right? So the prosecution has to bring it out. The only problem with them bringing it out is they'd be bringing it in under direct examination. They cannot ask leading questions. They cannot cross-examine, obviously, because they're bringing it out. But it would be, I think, if I was on the state side, I would definitely bring it out. But yeah, this is going to be helpful information for her, no doubt.
Those opening statements could start as early as Tuesday in this case. You heard Kelly Craft say jury selection likely to be wrapped up. The judge wants it wrapped up on Monday. While we wait, let's bring back in National Trial Attorney Michael Jaafar, who has been analyzing this case. And Michael, I do want to play a bit of the testimony from Marsha Thompson. It's always a big deal when we have the defendant on the stand. Everyone expected her to testify because you really can't get into this being a battered spouse syndrome case unless you open yourself up and tell both sides your side of the story. Let's listen back to part of Marsha's testimony where she talked about her husband's previous marriage and what she learned about that.
So you were aware that he had been previously married?
Yes.
What was the first thing that he revealed to you in terms of his prior violence?
The first thing was how he attacked his ex-wife with a machete and threatened to kill her and slit her throat.
What is his second wife's name?
Well, Melissa is the second wife.
And she's the first one you found out about?
Correct, yes.
What is the next thing you found out about?
About his first wife,
What's her name?
Christine Thompson.
And initially he had told you that she was just keeping the kids away and that was the problem between them.
Yes, that she would they had one daughter, keep the daughter away, and that she would go to his job at corrections and disrespect him and act crazy out in front of the workplace.
And what did he state later?
He stated later that he threatened to kill her as well to keep her in line.
Did he initially reveal this during an act of abuse toward you?
Yes.
And why was he telling you this?
He was trying to scare me and it worked.
Michael, one of the difficulties in a trial like this with the prosecution is that you don't want to make another trial where the victim, the shooting victim in this case, is on trial as well. Like, are you surprised that they did not, as far as the defense, try to bring in these ex-spouses, don't know their status, don't know what their availability would have been, but the judge also has to make sure this isn't a trial within a trial?
If we recall, there was a little debate between both attorneys and the judge, which was remarkable while the state was still had their case. When the judge had ruled that the statement could only come in a limited capacity about his prior convictions, and then the defense attorney stood up and said, but obviously when she testifies, if she testifies, she can talk about it. And the judge said no. And the attorney said, wait, so if she testifies, she cannot say that she knew that he was charged with battery of a prior spouse? And the judge said yes. And then as the judge said that, she knew the mistake and she realized, oh, wait a minute, this is too much. Of course you can. And then she said, I'm going to reserve ruling for that time. That to me shows that if they tried to bring in the prior spouses, I don't know if the judge would have allowed that, because you barely allowed her to testify, which would have been appealable error, by the way, if the judge did not let her to get on the stand and say, I knew at the time when I shot him that he had all these prior, he had this baggage, and this baggage caused me to be in fear for my life and caused me to feel that, he'd do the same thing to me, and he was kind of trying to threaten me. So at the end of the day, this case takes me back to law school. If only they had projector screen in our law school classes and they played a case like this. This case has everything. It has everything. You have the former law enforcement officer who's trained, who was wearing a vest, who at the time, which is why the state of Florida came at her with a murder 1 charge, not a murder 2. But at the same time, hearing her testimony and scripting, they've got the perfect victim, the defense do. I mean, they've got a victim who is just a monster, right? So you've got this monster married to this well-trained, seasoned, basically, RoboCop, and they're together and they have kids, and she's rubbing his feet to de-escalate him. But he didn't get off the couch, and he was killed while he was laying down. Wow. You can teach an entire law school class from this case alone. I am so riveted by this, and it's just, it's crazy how law school-y this is. It doesn't cut either way, clearly. It's going to be a tough job for this jury. They're going to be in there like roosters knocking heads.
It's going to be a tough job. That's probably why it came to the point of a trial. There was no plea deal, no arrangement before this. It's just a jury who's going to be able to make this decision. Bring in our analyst who's standing by, national trial attorney Mike Jaafar. Michael, you said that an ex-wife would not be able to be called. This was before we even knew that the defense was going to try and get this testimony in. And you said this judge, in the way she's reacted to other prior bad act testimony. Your thoughts on what all we've seen in the last 30 minutes?
This whole thing is wholly irrelevant. This judge is not going to allow it. And what the viewers are seeing also is something else with this judge. This judge is very upset that there's even a request to postpone this trial and send the jury home and bring them back on Monday for somebody who knew about this case for 5 years. And look at Court TV over here, helping people violate the rules of sequestration.
Oh, don't say that, Michael. They're supposed to be instructed not to watch us. Don't say that.
No, I know, but it was really comical because it's so important. Like, everybody in the country watches Court TV, and so this lady's admitting, hey, I violated this rule of sequestration. I'm watching Court TV, but I can't get here. I'm gonna get a flight, and I might get there on Monday. It was crazy. It was really comical. But this, her testimony will be wholly irrelevant because the defense, the crux of the defense is she killed him, and the justification for the killing is she was battered wife, right? And so you have to prove that she knew all these things. Well, if she's never spoken to this lady, she's never spoken to the ex-wives, it did not inform her decision to kill the guy. So it's wholly irrelevant. This judge wants to get this attorney to just give up so that she doesn't have appealable error. That's what she wants, and the attorney's not doing it.
Michael Jaafar, thank you so much for all of that analysis.